to avoid probate is, and I'll get to that, there's different types of ways that probate can be avoided, but generally if someone passes with assets in their name and they leave a will, you still need to go to the probate process. So during the probate process, if there's a will's validated, a person's appointed as a personal representative, and that person is the one that's in charge of gathering all the assets of the decedent, any probate assets that are left, paying any bills that are left, and then distributing the assets or the whatever is remaining to the heirs or beneficiaries. Okay, so this is really important to go over, and personally for people too, to know what type of assets are not subject to probate and what is subject to probate. So property owned jointly. This is like, let's say you often see title when people are holding title as joint tenants. So at the death of one, there's an automatic survivorship clause. So at the death of one, survivor takes. So if assets are held in joint tenancy, you don't need to probate because if the survivor is alive, the survivor takes all, and they're now the owners of the property. Also, joint bank accounts. So when you own an account jointly, someone passes away, survivor takes all. This is common with older people. They add a child to their bank account because they say, okay, well, just in case something happens to me, the person passes away, whoever's on that bank account becomes a sole owner of the account. Other siblings or whatever, they can't do anything about it. Why? Because by adding someone to an account, you've created them a joint owner. Okay, so that does not pass through probate. Also, here in California, it's common to hold, or we have the community property laws, so it's common to hold property as community property. However, it's very, very important that after it says community property, that it says with rights of survivorship, because community property does not have an automatic survivorship. So if someone holds property as community property, if one spouse passes away and it does not say with rights to survivorship, that 50% is subject to probate. So if the person left a will, you would have to probate the will, or there's something, it's a short form probate called the spousal property petition that I'll get into in more detail. So those are examples of property that does not go through probate. Let me go back. Other types of properties are assets, I should say, assets that have named beneficiaries. So if an account has a beneficiary, that asset goes to the named beneficiary. So you have the IRAs, any retirement plans, pensions, and life insurance, and particularly trusts. So property in living trusts do not need to pass through probate. And if anyone has a question or doesn't understand the term, please feel free to ask, because this is like second nature to me. So I speak and I talk and, and I think everyone understands, but please don't hesitate to ask. Okay. Assets that are subject to the probate administration. So generally, real property held solely in the name of an individual will have to be probated, and assets that have no designated beneficiaries. But there are some type of exceptions that I'll get to. So tenants in common, when real property is held as tenants in common does not have the automatic right of survivorship. So if someone passes away, their interest would have to go through probate if it wasn't transferred to a living trust. This is very common to hold property as tenants in common when there's, let's say, siblings purchasing the property together, or friends, partners. Reason being is because if someone passes, you don't want your share to be passed to the survivor. You would want your share, your interest in the property, to be passed to your heirs. So tenants in common, if there's no trust, then it would have to pass through probate. Sometimes there's some short form probates that you can use for property where there's partial interest held. So this is just, yes?
If you, in a tenants in common situation, then one person has a trust, would it be tenants in common, the name of the sibling, say, and then the name of the trust on it?
Yes.
Oh, okay.
Yeah, or so typically how it happens is, let's say Joe and Jane, 50-50 as tenants in common. Joe creates a living trust, transfers his 50% interest to the trust. So, or unless they buy together at the same time, they already have the trust, then it'll be the living name of the living trust, an undivided 50%, and then the other person's name.
Okay.
Yeah, and then that person would then have to create their own trust to avoid probate. Yeah.
What if I see some title that say like a married man and is so and separate, or a married woman? How does that go?
So if that, okay, so that's,
Happens to them.
and something happens to them, it would need to be probated. There are some exceptions though, okay? And I'll go over that right now. So if like I said, there's some short form probates. And it depends on the value of the property as of the date of death of the person. So sometimes you'll get a client and you'll say, oh my gosh, this is a probate. Here's the attorney. The probates are so expensive. And then when I see the case and I said, you know what, I have good news for you, right? But this doesn't apply all the time. This is sometimes. And it, like I said, it depends on the value of the property. So this usually happens when the person died a really long time ago, or they own just a partial interest. There's something called a petition to determine succession of real property, which is a short form probate. And I say short form because you still need to go to the court. There is still a hearing, but it doesn't take as long as the regular probates do. So what the petition to determine succession of real property is if you have a property that is less than, well, it depends on the date of death. But if the property right now, if it's valued at the date of death, $184,500 or less, then you can petition the court for this. So what it really is saying, let's say someone passed away, they own 25% of a property, right? And this person who passed has 3 heirs. They're 3 children. So the 3 children would all have to sign the petition saying, we are the lawful heirs of this person. What this person left was a property that was valued less than $184,500. Then there's a hearing, the court confirms it, and then just makes an order saying these 3 people are the owners of this 25% interest. Like I said, it's just one petition, one hearing. If there's no objections, everything's fine. But you still have to go to court, so it still costs something. There's also, and there's something that's even more simple, but it is a process. It's called an affidavit regarding real property of small value. This usually applies when there's vacant lots. I've never seen it really apply to home. So if the property value is $61,500, again, this time you don't even have to go before a court. It's an affidavit, a form that the court already has that you fill out. You submit it with a death certificate and an appraisal indicating that the value at the time of death was less than $61,500. The time of death is important because over the years they've increased the amount. So the last increase was on April 1st, 2022. So if the person died before April 1st, 2022, that value for that affidavit is $55,435. If it was after, then it's a $61,500. As for the petition to determine succession of real property, currently it's $184,500 or less, but that's if they died after April 1st, 2022. If they died before, it's $166,250. It used to be $150 before that date, but as time comes, they do some type of calculation and inflation, they raise it. So those are all short form probates. They're fairly simple. Yes?
One question. So say people have multiple properties, San Diego, LA, let's say Ventura. So the owner of the property dies in San Diego. So the probate would be in San Diego where it would be recorded, or?
So the probates are initiated at the county of residence. So if he was even though he had property in other counties, the probate would be at their residence at the time of death.
Second question. I'm just brought it out. Say if you're, I know it's going on probate. You're single, you own property, and no, you're not married and no kids. I know that's probate, but would nephews and nieces come involved into that probate transaction?
It depends. So I'll get to that. I have a slide that actually addresses who would be the individuals entitled in the probate. I mean, maybe if the person has a trust, then they can pick whoever they want, a neighbor, a friend, whatever, right? So not necessarily it's the nieces and nephews, but there is an order that the law has in place. It's called the laws of intestate succession. So if you die without a will, with nothing, the law puts in place how you would distribute your assets, right? So they kind of like create a will for you, per se. For the most part, it's mostly what people want, you know. Generally, I said not for the most part, not everyone would want that, but yeah, there's already an order how property will be distributed if you die without leaving anything. Then there's also for collection of personal property, because not everyone owns real property, or sometimes the real property is already in the trust and then they just leave an account outside. So this would apply to, let's say, life insurance proceeds, retirement accounts, bank accounts. So it's called an affidavit for collection of personal property. And what that is, again, we use these numbers up here, and if the amount in that account is less than that, or less, you fill out an affidavit before a note. All the heirs need to sign, and then they submit it to the bank, the life insurance company, the retirement, and then it gets distributed to the heirs at law, or if there's a will, to the persons in the will. So that's for personal property. Then we have, and let me go back to your question. The spousal, so you said someone buys a property and they buy it separate, sole and separate, married person, sole and separate property.
Yeah.
Okay.
Married man or married woman is so separate.
Okay, so under the laws of California, community property is anything that's acquired at the time of marriage and on, right, until death or separation. So if the property was purchased during the marriage and it wasn't a gift or an inheritance, because a gift or an inheritance is separate property, so technically it was not, it's not community. But if it's community property, so this is very, very common. Sometimes the spouse doesn't qualify to be on the loan, so whatever reason, the lender only wants the person that's qualified to be on title, right? So they purchase the property, then the person dies. Then another short form probate, it's called a spousal property petition. So what you're asking the court to do is, because we are in a community property state, we're asking the court to confirm that although it was held in the decedent's name alone, that 50% already belongs to, let's say it's me, right? My spouse dies. I want to say 50% already belongs to me because this was purchased during the marriage and we used community property to buy it. But I had bad credit and they didn't let me be on title. I didn't know that this was going to happen. You just show, you know, payments made from joint accounts. You have the children signs consenting to the transfer. So you say 50% already belong to me, and the 50% that was to the decedent should be passed to me. So that's used to award the property to the surviving spouse. And also if there's a will, it makes it easier, because if the will names the surviving spouse as the heir, then you just transfer it over. Yes.
So does that apply also, like, let's say I'm married, we live in California, then we buy a house in Texas, in Nevada, Las Vegas. Does that same thing applies for those states as well?
Well, I wouldn't know because I'm only a California attorney. So probates, you can only probate property in California, right? Here in California. So for those other properties, then you would have to do they're called ancillary probates in the other state, because California wouldn't have jurisdiction over the property in another state. Yeah, so there may be something similar. Not all states have community property laws, so it may be a little different. Yeah.
So in that case, only 50% of the value is going to be assessed through probate or do they 100%?
No, 100%. But in a spousal property, what you're asking the court to do is you're asking them to confirm that 50% already belonged to you. And then that the other 50% be passed to you, so it's 100%.
But for value purposes, is it 100%?
They don't value it. At that type of petition, they don't give a value because they don't care what the property's worth. The only ones that the value matters is for the other short form probates.
And in regards to value, is just the balance that they have that they owe to the bank, or is it whole?
The entire amount. Yeah, they don't take into consideration the debt, so that it's just the value. And these values, there's something called a probate referee with their appraisers, and they're appointed by the state controller, so they're the ones that give the value. So it's not a regular appraiser. They have to be a probate they're called probate referees that do the values.
I was wondering if you have a probate referee, they come in, they value the house. In the past, they did drive-by land comps, that's pretty much they give you the value.
Correct.
But what if before the deceased became deceased, they did the kitchen, bathroom, everything, and as a realtor, you take pictures and say, hey, by the way, we can give it extra value because modified kitchen, modified bathroom, does that still apply?
Yeah, you can, but that actually, if you're going to look for a short form probate, that won't help you, right? Because you want to avoid probate, so the lower the value, the better. That's probably better when you're in a full probate. You want to higher sometimes you want to higher value, and then it's going to help for capital gain purposes for the sale. But generally, you would want the lower value for these types of petitions.
And can you tell us how long a spousal petition would take from beginning to end on average?
So it depends on the county. Like right now, LA will schedule them 2 to 3 months. Riverside schedules them pretty fast. San Bernardino takes a little longer. It would probably be 2 to 3 months to do it. But it's always a good idea before having someone sign a listing agreement, make sure you look at title and see who are the actual owners. Because I've had many cases where a realtor calls me and says, hey, this is urgent. We're in escrow and the person on title is dead. Well, there's, right? So it's like, well, he's like, can you rush it? No, that's not my fault. That's not, the court doesn't care, you know? Unless it's a foreclosure, then it's kind of different, but there's no urgency. The judge isn't going to say, yeah, let's rush this because the realtor wants to get paid, you know? So it's always a good idea. Check title before even listing the property. Yes.
So if it's a blended family and they've been married for 20-some years, and let's say the mom owned the home, passes away, does that mean that the husband gets 50% and the children get the other 50%?
Well, depends. So if the husband's not on title and it is separate property because she owned it before, then it's going to go towards the laws of intestacy of it being separate property. So if there's more than one children, the spouse would be entitled to 1/3, and then the children would share the 2/3. If there's no will or trust. Yeah. So here's to answer your questions about a petition's filed in the county where the decedent resided at the time of death. If it's an out-of-state decedent and they own property in California, then we would probate where the property is located. So if they lived in New York, had property in LA, the probate would be in LA, or any other county that they had property. So if there's a will, we call it testate. The probate is a testate succession. And if there's no will, we call it intestate. So usually when there's a will, the will indicate who they want to be the person in charge of the estate. Who's going to be the one that's going to gather the assets and do the entire probate administration. If there's no will, then the law has in place a priority for appointment. So it starts at the spouse, the children, then the grandchildren, and it just goes down the list. So whoever is alive, they would have a priority of being appointed. So if there's a surviving spouse, that person's the one that has priority, and the children can't go and file the probate. They would have to get permission from the spouse or prove that the spouse isn't competent to handle the probate administration. So then we have the petitioner. Well, the petitioner, which would usually is a family member of the decedent, they file the petition to be appointed to administer the decedent's estate. And at that time, they'll seek either full authority or limited authority, which is very, very important for probate sales, because then that determines how the process is going to be, whether the person has full authority or limited authority. So the probate process generally takes between 9 to a year and a half. Could be longer if there's, issues, disputes between the family. So initially, then this is a very, very, very simplified process. So how it starts is someone files a petition to be named the personal representative. Before the hearing, there's a publication of the probate in a newspaper that's circulated in the area where the decedent resided, or if they did not live in California where the property is located. What the publication does, it's kind of a notice to the world saying, hey, this person has died. If you owe money, come and file your claim, right? Believe it or not, there are many claims that get filed because of the publication. I think credit card companies probably have people that are looking constantly to see who passes, and then they submit their claim with the court. Then you have the hearing. On this hearing, if the petition's fine, the court will approve it. Thereafter, the person, within 4 months that the letters are issued to them, the letters is a document that gives the personal representative authority to act on the decedent's behalf. They need to do an inventory and appraisal, so they list all the assets that the decedent left that are subject to the probate administration. If they have limited authority and they're going to sell the real property, they need to do what we call a report of sale and petition to confirm sale of real property. And that's needed when the personal representative only has limited authority. And I'll get to the difference right now, okay? Thereafter, everything's been paid, all debts have been handled. You file an accounting, and it's a final petition with the court to say, okay, everything's settled, now you can distribute the funds. A lot of heirs believe that once the sale is done, that they're going to get their money right out of escrow, which is not the case. The sale is a regular sale. Everything's closed, the commissions are paid, buyer takes possession, but the probate doesn't end. The probate keeps going. And then you get your order, and then you can do the distribution to the heirs. Okay, so limited versus full authority. I know realtors love full authority because it's super easy, regular sale. All that's done is when it's time to sell a property, the attorney for the personal representative or the personal representative will send out what we call a notice of proposed action. And all it is saying, hey, we found a buyer for this property. These are the material terms of the sale. The sale will be made by a date, and then they have 15 days to object to the notice of sale. Sometimes people will object if they want to buy the property, they think that the price is the price is too low, many reasons. But if there's an objection, then it has to go through what we call court confirmation. People get limited authority for many reasons. One is because the bond amount. Every time there's a personal representative, they need to be bonded. And what that means is that they need to have an insurance. The court wants the personal representative to be insured over the estate, because let's say there's money involved, that person has control. They have an account. Although it's in the name of the estate, they're the ones that have control over it. So they can easily spend the money. So what the bond does, it covers the heirs. So they say, okay, well, there's $50,000 in the bank, and you have a real property. Well, we're going to issue a bond of $50,000. That way, if they do anything with that money, the bond company covers the heirs, and then the bond company will go after the personal representative. So minimum for real property, let's say that there's no account or there's an account less than $20,000 and there's real property, the court's minimum bond is $20,000. I think in San Bernardino, it might be 30 now, but it's a nominal premium. So for a bond of $20,000, the premium is about $150, $200. To get the bond, they do a credit check. So sometimes the personal representative doesn't qualify for a higher bond, so there's no choice but to get a minimum bond, and then that way they only have limited authority. Or sometimes a personal representative doesn't want to pay the bond amount, right? So if, let's say, there's a real property is worth $500,000 and it has $500,000 in equity, then you have to get a bond for $500,000. A bond premium for $500,000 is between $1,500 to $2,000, and this is a year. But sometimes people don't want to pay that. They say, why? I can just go limited authority. So that's the difference between why people choose limited authority. So limited authority, you'd have to go through court confirmation, but your bond is lower. Some people also like limited authority because at the time of the court confirmation, there can be overbidders. And I'll get in detail with that. Okay, so full authority. Full authority, you have a higher bond because you have more access to, you can sell without the court's permission. All you have to do is send this notice, and once the sale is done, you're going to have all that money into an estate account. So for the bond is always higher when you're going full authority. It's actually the value of the estate. So if there's an annual gross income, you add that plus the net value of the real property, which will give you your bond amount. Like I said, sometimes it's not possible to do it because the person doesn't qualify for the bond. The court confirmation may be required, and I say maybe is because once you send out that notice that you're selling the property, if there's an objection, then you have to go get it confirmed by the court, the sale. Any questions? No? Okay. Okay, so limited authority for the real property sales. So, like I said, for limited authority, a report of sale and petition to confirm sale of real property is required. Once that petition is filed, the hearing date is set, usually 30 to 45 days from the filing. Notice to the heirs, the notice of the hearing is given to all the heirs at least 15 days before the hearing date. Again, notice is given because they do have the opportunity to object to the sale. You also need the personal representative also needs to do a publication for the sale. That's how I think a lot of people, investors generally, get notice of these type of sales through the publication. Deposits of 10% are usually required for the court confirmation. It's not mandated, but it's just what's practiced. You get 10% for these type of sales. If it's been over a year since the date of death of the decedent, because sometimes there's years pass until people or family decides to finally probate, you have to get a reappraisal of the property. So if someone died in the year 2010, obviously the value that the probate referee gives, because the value that is given is as a date of death value. But if it's been years, then you have to get a reappraisal that's within 1 year of the time that you're selling, to see what the property is worth at that time. Also, the property needs to fall within 90% of the value given by the probate referee. So that is, the court will not confirm a sale if the property is valued less. So it has to fall within the 90% value, which comes back to your question where there's been remodeling done, it usually doesn't help when we do these types. We usually do the opposite. We show the property is not in a good condition to try to reduce the value so the offer that's in falls within the 90%. Because sometimes, well, most of the time, the probate referees do not do an interior inspection of the property. It's just a drive-by, and they look at comparables. So sometimes you get this property that you're trying to sell, and they give you such a high value, and it's impossible because none of the offers coming in are going to be within the 90%. We contact the realtor, we say, hey, you need to do a little report, pictures, and send and comparables of why you think it should be lower. They find their buyer. Again, overbidders, if you do have clients that are overbidders, they do need to do their due diligence before going to court to overbid. Because like I said, once the court orders the confirmation, I mean, you have the same terms of the previous sale, no contingencies, so the sale needs to move forward. Okay, so this is just the overbid formula. So if you ever see on the MLS that there's it needs to be confirmed by the court, for you to know what the minimum overbid amount is, here's the calculation. So you get the original bid, and then you do, which let's say in this example, the original bid is 5,000, then you get 10% of the first 10,000 of the original bid, so it's 1,000. 5% of the original bid minus 10,000, so there you see my calculation. Then you add that all up, and then you get the minimum overbid amount. So if you someone's going to go to court, they have to offer at least that to get the property. The buyer, the original buyer, also has the potential to overbid at court if they really want the property. And then this is the probate sales when there's full authority. Like I said, court confirmation only may be required, just generally not unless there's objections. When property is subject to court confirmation, there's a limit on the commissions. LA County is 5%, 10% for unimproved lots. Orange County is 6%, San Bernardino County is 5%, and 10% for unimproved lots. When there's an overbidder, the realtor for the overbidder gets what is paid extra. So the seller's agent doesn't get the commission for the overbid amount. So an example, let's say it was a $300,000 sale, the commission's 5%. $7,500 for each seller and buyer's agent. But then if you have an overbid amount for $315,500, which is a calculation for a $300,000 sale, the seller's commission stays at the $7,500, and then the overbidder's agent will get the $7,500 plus the extra that was paid in the overbid amount. Okay. So, yeah.
Is that monitored?
I'm sorry, is it monitored? Is it monitored?
Yeah, by the court.
Usually the court, okay, so sometimes, okay, so like, let's say sometimes the judge will just say, okay, commission, and then split it, right? But some of the judges will be like, no, this isn't how it's done. Like, this is the technical way of doing it. Like, this is what the law is, right? Or sometimes the buyer's agent will be like, no, that's not the commission. The commission is, and then they get the little bit more. Yeah. So kind of monitored, right? So it really depends on the judge. And if I usually don't speak up, and I just stay quiet when it's the overbid calculation. One, because I'm trying to do the math while, and I'm like, hopefully the judge just splits it because I don't feel like doing the math right now. And I just leave it up to the realtors, you know, if they know what the rule is, then they can get their split. Okay, community property. Like I said, community property in California is any property that's acquired during the marriage, except for gifts or inheritance. So upon the death of a person and a property's community property, this is the laws of intestate succession. So this is if someone dies without a will. If there's community property and someone passes away, the 50% of the community property of the spouse is entitled to the surviving spouse. So this is this is common when you see a spousal, when you see a property held in community property, but they don't put those words with rights of survivorship. You can file a spousal property petition if there's no will, or if the will names the spouse as the heir. But at that case, kind of like when you said that if you were asking if only 50% passes through probate, in that case, only 50% passes through probate. Because if they're both on title as community property, the spouse already owns 50%. So then they're just asking for the court to pass the decedent's 50% to them. So that would be an example of when only 50% passes through probate.
Can I ask you something?
Yeah, of course.
A while back, I mean, they only used to do joint tenants.
Mm-hmm.
What happened to all those people that bought houses 25 years ago, 20 years ago? The right of survivorship is not something that is there all the time. So there's a lot of people that have it as a joint tenant. Does that create a problem?
It creates a problem when the survivor isn't the intended heir of the property, right? So like, because you've had title like that for that many years and you could have changed it. So let's say you have a brother and sister, they bought a property together. They now each have families together, like separate, their own families. One of them dies while the survivor takes all. And if nothing was done and the survivor doesn't want to give the share to the others, then, I mean, that's going to create a conflict.
Yeah, but when there's husband and wife, it shouldn't be.
Yeah, when it's husband and wife, it's not a problem at all.
Of documents
right. Right.
I mean, yeah,
when it's husband and wife, it's not a problem because the survivor takes. The problem comes when the survivor dies, because now the survivor needs to go, their heirs need to go to probate. So even though if it was a couple from years ago, it doesn't matter. The joint tenancy is still there. And if there's, let's say, like I said, if there's siblings that bought a property together and they're held in joint tenancy, well, it's hard to rebut the presumption that of the survivorship, especially if it was held like that for so long. They can say, well, it was like that, they can change it. They never did. To break the right of survivorship, all you have to do is transfer your interest, and it breaks the right of survivorship. So a right of survivorship is created at the time that the transfer is done, right? They have it as joint tenants. But if someone thereafter transfers their interest to their trust, you break that right of you break the joint tenancy, or you just file a new deed transferring it, and then you're now a tenant in common. Yeah.
So when you have a trust, that goes into the title as a trust, correct? Not joint.
Correct. Yeah. So you would do, if it's a couple, they would do a joint trust. Yeah, so they would jointly transfer the title to their trust. Yeah. So this is kind of where you asked about the single person not having a spouse, no children. So this is the laws of intestate succession when there's a surviving spouse. My next slide will be no surviving spouse. So if there's a surviving spouse and you have children, your surviving spouse gets, if you only have one child, your surviving spouse gets 50%, then your child gets the other 50%. If there's more than one child, your surviving spouse will get 1/3 and the children will share the 2/3 equally. If you have a surviving spouse and you have a predeceased child, so a child who died who left children, the grandchildren will get, and again, it depends on the amount of children you have. They'll get either 50% if there's one children, or 2/3 if there's more than one children. If there's no children, but you have a surviving parent or surviving, or their issue, meaning your siblings, your spouse gets 50%, and this is when it's separate property. Your spouse will get 50%, and your parents will get the other 50%, one or both. If there's no parents, then it goes down to your brothers and sisters. If your brothers and sisters have passed, it goes to their children. To their children. So your nieces and nephews. Okay, so this is a separate property, no children. It goes to your parents or siblings or nieces and nephews. Okay, so no surviving spouse. If you have no surviving spouse, but you have children, it goes to your children in equal shares. If a child has died, it goes to their kids, so it would be your grandchildren. If you have no children, it goes to your parents equally. If you only have one parent, well, everything goes to the survivor. If you have no parents, it goes to your siblings. If a sibling's passed, it goes down. It's kind of like it trickles down. It goes down to your nieces and nephews. If you have no siblings, no nieces and nephews, it goes to your grandparents. If you have no grandparents, it goes to your aunts and uncles. If you have no aunts and uncles, it goes down to your cousins, and it will. If you leave nothing, yeah. If you do nothing at all.
So if they don't find anybody?
So then it's called, it goes to the state. It goes to the state. So, I mean, they try to find someone, they do the effort. So like, let's say you have this one right here. You have no children, no parents, no siblings, no grandparents, no aunts and uncles, no niece, no cousins. Then it'll go to the children of your predeceased spouse. So like if you were married, but the person died and they had kids, they'll give it to your stepchildren before. Or if that's the case, then it'll go to if there's no stepchildren, they'll go to your next of kin. So you try to find someone, right? Then at the end, like this, you have no stepchildren, no next of kin. It goes to the parents of your predeceased spouse or the siblings of your predeceased spouse before it goes down to the state. So you try to find someone. So you know, there's like heir searches. So sometimes like people randomly get something in the mail and they're like, oh, I'm an heir to this, you know, that person you never met in your life.
But the one I'm working on, he doesn't have anybody. He passed away. He don't have anybody.
Nobody at all.
Nobody at all. So it goes to the state.
The state will keep the money. So yeah. So what happens is usually a public administrator gets appointed. Okay. So county council will represent the public administrator. Right. The public administrator does the probate process. They try to find someone, and then after that, they hold it, and then after they send it to the state controller. Then if nobody claims it, then it goes to the state.
It still have to be approved.
Yeah, it's a process. It's a very long process before the state cares. Even for the state to get it, yeah. Because even after that, I don't know if you've ever looked at the state controller website. There's like an asset search where you put your name, and then they'll see if something out there is for you. So you always, so when you start the probate, you do that. It's usually like $1, $2, some type of refund that you never cashed or something. Yeah. But sometimes it's more. Sometimes it's a lot more money. Yeah. So that will happen. They'll hold it until the time. There's a certain time limit that they have to hold it, and then they'll keep it. Yeah. But I think it's pretty long, the time. Yes. Yeah, I'll send a copy to Hugo so he can forward it to whoever would like it.
You're gonna share that, right?
Yeah, I'll send it.
If you guys want a copy of it, just reach out to me and she'll get it to me. I'll shoot it out to you.
Okay, thank you.
Okay, so the probate, usually people want to avoid probate because it's costly. Just to file a petition, it's $435 plus they charge for a court reporter fee. Except in LA County now, there's no court reporters, there's a shortage of court reporters, so now they only charge $435. But typically it's $465 for a petition. The publication to start it really depends. That's on the low end. Everything's like more expensive now. The publication, like I said, to start the probate, there needs to be a publication in a newspaper. It really depends on the city where the publication is done. It ranges from $200 to $800. I know Pomona has like an $800 fee. So that's on the low end. Bond premium, $200. Again, that's if there's limited authority. Then the probate appraiser the probate referee charges 0.1% of the value of the property plus expenses, which I guess it's usually they say their mileage for their gas or whatever costs they claim. But it's 0.1%. So if you have a property worth $500,000, your probate referee fee is going to be $500 plus cost. Then when it's limited authority, you have to do a publication for the sale. They generally charge $180 for that. Then again, another $435 for the actual petition. And then when you do your final accounting too, it's another $435. So every petition that's filed with the court, it's a $435 fee plus the e-filing services fee. So $2,200, that is just a really rough estimate. It's usually now between $2,500 to $3,500. It just really depends on the case. But this is on the low end.
And county, each county?
It depends on the value and the size of the estate, whether you go limited, full. The higher value the estate, the higher appraisal fee there's going to be. Yeah. And the higher the probate bond will be. Okay, attorney's fees. This is what is, I guess, the biggest cost in the probate is that attorneys charge what we call a statutory fee. It's set by the law. It's 4% for the first 100,000, and this is the gross value. So it's 4% for the first 100,000, 3% for the next 100,000. Anything over 200 up to $1 million, we charge at a 2%. So the higher the value of the estate, the higher the attorney's fees are. The personal representative also gets to charge a commission for being the personal representative, which is the same amount of the attorney's fees. So also attorneys charge extraordinary fees, and extraordinary fees are we charge on an hourly rate in addition to the statutory fees. So anything that's considered outside the normal ordinary administration, it's considered extraordinary, like sale of real property, helping the personal representative do the tax returns. If there's issues, like if there's a foreclosure, we had to file a restraining order and stuff like that. That's all extraordinary. Yes?
In certain transactions in a probate, there might be a notice of default stage, notice of sale. Do you usually get involved with that, doing maybe an ex parte?
Yeah. So when it's at the notice of sale, it's really hard because you have such a short period of time. If it was just recorded, I personally will take it if it's just recorded. If it's like you have a week, then I look at my schedule, I'm like, I can't do it. It's just, once there's a notice of default, they need to move on it, because then they give you sufficient time from the time of the notice of default until the time of the notice of sale to actually start the probate process and get letters issued. So yes, I'll get involved with the notice of default. The notice of sale, it really depends on how fast the sale is.
What's your fee for an ex parte when you're on a notice of sale?
So I'll charge the hourly rate. I'll charge an hourly rate usually. Yeah, which is then paid at the end of the probate as well. But in those type of cases, because you don't know if it's going to be saved or not, the clients would have to come up with a retainer to cover the cost. And what he means is an ex parte is it's an emergency hearing. So an ex parte is to expedite the process. So in order to, if there's a notice of default, you want to get, they won't issue you your general they won't issue the letters of administration, the general ones, but they will issue you something called special letters. And by having those special letters, it will allow you to either list the property, find the potential buyer, and then sell it on more in an expedited basis than your regular probate. And then if the time comes of a sale, then you also have the authority to file a restraining order to postpone the sale. You won't stop it, but you can postpone it. Most banks, once you file this restraining order, they'll work with you, because the court then sets out a hearing date to follow up and see what's going on. They'll work with you if the property is listed. If the person's not doing anything about it, then they're going to say, no, I want my money. Yeah. Yes.
Say if you own property and you rent out the property and the owner dies and they have tenants, so when they sell the property, do they go into the eviction notice at the same time, or the owner of the property has to go to the eviction notice of the tenants of the property that they just purchased?
So it depends. What happens when there's a probate? The personal representative steps in the shoes of the decedent, right? So let's say if they're going to keep the property, then they just continue, right, collecting the rent, doing the whole probate process until the end. Rather than distributing the money, you're going to distribute the property. There's going to be a court order saying that the property is distributed. But if the person wants to sell the property, it's going to be the same thing as a regular sale. They're either going to sell it with the tenants or without. If they sell it with if they want to sell it without the tenants, then they're going to have to do the whole eviction process, serve them with the notices. If it's going to be the 60-day notice to vacate, if they stop paying rent, the 3-day notice, exactly what it is if the person were still alive. It's just that the person now steps in the shoes of the decedent. Yeah. And if you're in an area with rent control, then it makes it much harder. Yeah. So this is just an example. So in order to calculate the commissions, we look at the gross value. So the debt isn't taken into consideration. So for an estate of $500,000, well, we have 4% of the first 100,000, 4,000, 3% of the next 100, 3,000, and anything after. So the remaining 300,000 is at 2%. So you get 6,000 out of that. So the attorney's fees for $500,000 estate would be about 13,000. Attorney's fees aren't paid until the end of the probate. They're paid when the court gives an order, and then they're typically paid out of the estate. So after the sale of the property, the estate will have money. Sometimes when there's a few heirs, they want to keep the property, and at that point, well, then the heirs would have to come out of pocket for those fees if they want to keep the property. So yes, so all this can be avoided. Like I said, if you create a trust, it avoids probate. It doesn't avoid problems, it just avoids probate, because you always have problems too sometimes when there's a trust. But the whole probate process can be avoided with an estate plan. And then I just have general information in regards to how a trust works, which is another total separate topic. It's another class. Yeah. Any questions?
I got a question.
Yes.
Because I know a situation came up with a deal. So a lot of times people try to get into the investment mode, right? Working with a probate, and they work with, whoever the petitioner is, and they start fixing up the property, and they start, I'm going to invest in this property, and we're going to make money together and stuff like that. Going into contract with somebody that can't even or shouldn't even be going into contract yet, right? So do you see that? How do you see that? How can you get away from doing that, or how can you make sure, or at one point in time, can you legitimately go into contract to help them fix up the property and then to try to maximize their money?
Okay, so when a person, and I know exactly the situation that Hugo's talking about. Okay, when someone isn't appointed as an administrator or an executor, if letters haven't been issued to them, they have no contractual authority to make any contract. Like, they can't list the property because they don't have any authority. It's like you trying to sell your brother's house right now. You can't do it. It's not your house. Same thing if in a probate. Like, if the court hasn't issued you letters, then you have no authority to enter into the contracts. And if you were to, usually probate sales, they're typically sold as is. Right? The court doesn't want you to invest money in this property that you don't even know how much you're going to make out of it. In order for you to make that type of contract with someone legitimately, you would have to get it approved by the court. Like, hey, I found this person that wants to invest in the property, and then these are the terms. Because the main focus in a probate is the heirs, right? Whoever the heirs of the estate are. They don't care about an investor. They don't care if the investor makes money or not. So even if you would want to enter into a contract like that, it needs to be approved by the probate. If they want to enter into a contract like that, it can be pertaining to their own share of the estate. In this case, the person did get kind of a little lucky, and in addition to their commission, because I believe that they were paid back, everything that was owed to them. But in this case, the heirs acknowledged what was done, and they gave them a piece of their inheritance.
Which they didn't have to.
Which they didn't have to, but they did.
Come back and said, well, I don't know who you are.
Yeah.
There was no contractual. And then just to kind of do, so then the agent was kind of holding it against the attorney, the court, like, hey, well, this is my money and we have an agreement, and the house, they got more for it and this and that, but how can anybody acknowledge that, I mean, there was a contract that is not even a valid contract. So just kind of be careful when you guys see an opportunity, you know, who you're actually trying to go in a contract with.
Yeah.
Right?
I mean, they
talk to the attorney before you guys do anything, because trust me, it creates a pretty bad situation. You know, it makes sense when you're, you know, going into it, but then it becomes like, you know, the trust thing. It's almost like it's not a contractual thing, but, you know, you think this person is really going to pay you back at the end? Because it doesn't matter what you have signed, they have no authority to sign a contract or go into contract. So it's an invalid contract.
So the costs were reimbursed in escrow, because he did pay for it. So it's like, okay, let's reimburse him for costs. Sometimes too, when there's maintenance that's needed for the property just to get it to code, if they don't have money, they'll hire someone to do the work, and then they get paid at the close of escrow, which isn't a problem. And if it's going through court confirmation, it'll get confirmed by the court, the reimbursement amount. In this case, it was a notice of proposed action, which we included the amount of reimbursement that was owed to this person. So he did get money, additional money, because the heirs gave him money. And not only that, he was also the listing agent. So he did get, because it sold for a higher value, I mean, his commission did go up a little. So it's not like he went out with nothing. He just didn't go with as much as he expected.
He wanted to make, I mean, he was thinking like the same thing, you know, I'm going to invest so much money into it, and at the end we're going to profit, we're going to split the profits, that kind of thing.
Yeah.
So it's like, hey, I'll put this much money in, I put the money, but you're going to sell it for this much more, and we're going to split that. Well, he wound up getting the court only really gave him what he had proof that he put into it. But it wasn't up to the court to decide that the money being split or those profits that seller was going to have to pay them, because there was no valid contract to go for that.
Yeah.
Quick question, do you do, living trust or?
Yes, I do everything within the probate realm. So I do living trust, probates, guardianships, conservatorships, all that.
What's the average price for a trust?
So I charge for a single person, one home, $1,500. Any additional real property transferred, I increase it by $200. A couple, $1,800, and again, any additional real property, I increase it by $200.
Property is $200.
Yeah, each additional property.
So you do conservatorships as well, right?
I do conservatorships as well.
That's important, you guys.
Yeah. Yes.
Question, if the petitioner decides to sell the property and it's going to be listed for a fair market value, correct?
Mhm.
But what if a family member wants to purchase that property for a discounted price, maybe, I don't know, 70% of the fair market value? Is that allowed to do? Is that frowned upon? What's your take on it?
So it's frowned upon by the court, right? Because the court wants you to get the full market value, because your job as the administrator is to do what's in the best interest for the heirs or the estate. By selling it at a discounted value, well, then the court will see why are you giving this discount, right? If it's a family member that wants to buy the property, and if it's an heir, then you would just petition to the court for the sale. And if they want to use their share, like doing a calculation, but that would have to get that, by doing that, you would have to get it approved by the court. And not only that, the court would probably want all the heirs to consent to it, because really you're taking away from them by doing that. So if all the heirs consent to it, I mean, I don't know if the court would have an issue with it or not, but they would probably want them present, verbal consent at court hearing. I mean, I've never had that experience, but I'm assuming that's what the judge or court would want, because they don't want then the heirs to later come back and say like, hey, why was this sold for such a low amount? Yeah. Yes.
Record, What, you know, for anybody that wants to build a living trust, what paperwork or documents would you need to give to you to do the living trust?
A list of the assets. So I go over all the assets and what I recommend, like whether you're going to put beneficiaries on those assets or whether you want to transfer it to the trust. Like for example, retirement accounts, I never recommend transferring it to the trust because retirement accounts, when you're named as a beneficiary, you can roll it over and you avoid the taxes that you have to pay when you pull the money out. So when you name a trust as a beneficiary to a retirement account, you generally have to pull it out, pull the cash out, and then you get taxed on that money. When you name an individual, you can roll it over into your own account, and you avoid those taxes. So just a list of assets initially. Yes. Any other questions? Yes.
I put trust and then I want to refinance 6 months later, a year. What would be the process?
Yeah, so you can, because especially in a revocable trust, you are still the owner of your property because you remain as a trustee and the beneficiary of your own trust. Some lenders require you to pull the title out of the trust and put it in your name for the refinance, and then once your refinance is done, you transfer it back to the trust. Yeah, don't forget. Don't forget. There's something called too that because it's a common occurrence. They transfer it out and they put it in their name, and then they never transfer it back into the trust. There's something called a Hegstad petition. So a Hegstad petition, and I don't know if the person that helped them did that or not. Oh, okay. So it's kind of a short form probate, and what the Hegstad petition is, if there's a living trust and there's a property that was left outside, but it was somewhat mentioned in the trust. It was either mentioned there's a schedule at the end of the trust that lists all the property that's being transferred, or it has some type of general language saying, I want all my property to be transferred to the trust. We file the Hegstad petition and we have to demonstrate that it was the intent of the grantor, trustor, settler to have that property in the trust. And then it's a one-time petition, a hearing, and then if the court approves it, then it gets transferred to the trust.
What about taxes? So if somebody inherits $600,000 in the sale of the house, do they pay taxes to whoever?
So depends. So the taxes. So we're talking when we talk about capital gain taxes. We have if you receive a property by an inheritance, you receive something called the step-up basis. You receive the value of the property as of the date of death. So what they do to calculate the gain, they use the value as of the date of death of the decedent and what you sold the property for. So if a person dies and you probate right away and then you sell, more than likely you're going to sell within the fair market value, right? So the gain's going to be nominal if there's a gain. And even if there was a small gain, then you have all your deductions from the sale. So then at the end, you don't have to pay any capital gain taxes. In California, there's no inheritance tax. So the heirs don't have to worry about inheritance tax, just the capital gain tax. If you wait a long time, like a lot of people for whatever reason, like right now, I think I have a probate that someone died in the year 2001. So the value of the property then compared to now is huge. So if they sell, they're going to get a big capital gain. But thank God in this case, they're not planning to sell. They're going to keep the property. But if they were to sell, then they're going to get that value, which is still an increase from the purchase price, right? But yeah, you get a step-up basis. Then we have the property taxes, which is different. Unless someone's going to live in the property and it was the principal place of residence of the decedent, they're going to get a reassessment, and then they're going to have to pay a higher tax even after they die. So sometimes people don't start the probate. Let's say if someone when the law took effect, 2021, right? So now if someone died in 2021 and they're probating now, and then they find out that house, they don't fall within the exemption, they're going to get escape taxes. So they're going to have to pay the reassessed tax amount since 2021. So once they start getting all the bills, like 2021 tax bill, 2022 tax bill, 2023 tax bill, 2024 tax bill, they have a 8-year statute of limitations to go back. So they'll get a tax even though they didn't report the death, unless they qualify for Prop 19. Yeah, so you can't escape that tax. Yeah, and I don't know, Hugo, if you know, do you know how the county confirms whether it's actually the principal place of residence?
Based on when you do your taxes, your primary residence.
Oh.
So basically, they'll ask you for proof that you're going to be a primary residence, and you have 1 year. If you don't reside on the property, you have 1 year to actually move into the property so it doesn't get reassessed.
And file homestead declaration when you move in.
Oh, yeah.
Yeah, for them.
You can't use it as a vacation, like a vacation?
It's got to be a primary.
I mean, whether it's your primary or not, I don't know. I mean, that's on you.
Do you know how some people try to do? They try to move in there like for 3 months and then they move.
They move out, yeah.
They look at you. What are you putting on your primary residence? You know, your taxes.
Oh.
Yeah, because the law is if you move in, they'll give you the same amount. But if you were to move out in the future, then they're going to reassess.
So might as well tell the truth for fun.
Preferably, right? Thank you, everyone. Thank you so much. Thanks.